Recognized.
Mr. Speaker, I begin with an urgent constitutional public service announcement based on millions of calls and messages that have been flooding Congress. There is a serial constitutional violator at large right now in the District of Columbia, whose overall project to dismantle our Constitution and rule of law is now the target or subject of at least a dozen different federal court temporary restraining orders and preliminary injunctions across the land, and also faces emergency civil actions in dozens of other courts and jurisdictions. The suspect has been described as a very evil individual by Steve Bannon and has been operating in clandestine fashion with a night crew of computer hacking juvenile associates, one of whom goes by the alias of Big Balls, and another one they call The Kid, who has been known to post racist and anti-Semitic provocations online. The accelerating spree of constitutional offenses alarming the nation involves dozens of episodes of computer fraud and data theft affecting potentially 300 million Americans and escalating threats against congressionally created federal agencies serving the people, from NIH to the National Weather Service to NOAA to the Department of Justice, public workers, teachers and students, prosecutors of cop-assaulting criminals and seditious conspirators against our government, FBI agents, and anyone who depends on Social Security, Medicare, Medicaid, or any other computerized public payment system. The apparent ringleader of all the constitutional mayhem is a reported father of 12, a formerly deportable undocumented immigrant who worked illegally in the country and is apparently part of a loose network of Silicon Valley billionaires who oppose American constitutional democracy and openly favor creation of a monarchical techno-state under their control. The suspect was seen yesterday in the vicinity of 1600 Pennsylvania Avenue Northwest and is known to have been consorting as recently as a few days ago with a convicted felon from New York. Described as the richest person in the world, the suspect is both a government contractor with billions of dollars in defense contracts, and we learned yesterday $400 million slated from the State Department for some of his armored Tesla vehicles. And also, he is a part-time government worker whose many taxpayer-supported businesses are being investigated, fined, or sued by numerous federal agencies, including the Department of Transportation, the National Labor Relations Board, the Department of Justice, the Consumer Financial Protection Bureau, and the Securities and Exchange Commission. The suspect has allegedly been working to seize control over several of these same agencies to shut them down, which would presumably terminate all of the relevant threatening investigations. The public has never received from the suspect any ethics disclosure forms required of all federal workers, nor any conflict of interest waiver to resolve his glaring conflicts of interest. The suspect spent his formative years in apartheid South Africa and has been known to post racist and anti-Semitic material and to engage in a Nazi salute in public. Steve Bannon calls him a truly evil individual. The ringleader and his associates, sometimes called the Muscovites, have been seen by numerous federal workers violating the separation of powers and the spending clause, usurping the powers of this body, trampling the civil service laws, and violating the rights of both his federal and corporate workers. The suspect, his sponsors, and accomplices should be considered dangerous to the constitutional rights, freedoms, and institutions of the people, as well as their property, their jobs, and their livelihoods. If you know anything about the situation and you're a Republican member, please get in touch immediately with the Democrats so we can form a majority to stop this unprecedented attack on the Constitution and American law and order before we end up like apartheid South Africa or Orban's Hungary or Putin's Russia. Now, back to our regularly scheduled program where we avoid the constitutional crisis overtaking the first and greatest multiracial, multi-ethnic constitutional democracy on earth, and instead pass completely redundant, unnecessary and sloppily drafted laws that allow us to vote against immigrants, whether documented or undocumented, as Elon Musk was, without either engaging in comprehensive immigration reform or fixing the border. Now, with this bill, House Republicans are once again seeking to take political advantage of a horrific crime by seizing on the death of Agent Gonzalez in the performance of his duties, while doing nothing to make our border more secure or to repair our broken immigration system. And everyone knows, of course, that they blew up the bipartisan border security deal that we had at the end of the last Congress. But H.R. 35 seeks to establish new criminal and immigration penalties on anyone, citizens, permanent residents, documented immigrants or undocumented immigrants, for this offense: fleeing a Border Patrol agent or a law enforcement officer who's working with the Border Patrol. But fleeing Border Patrol at the border already carries substantial criminal and legal penalties under current law. That's already a crime. Under 18 U.S. Code 758, whoever flees or evades a checkpoint operated by the Customs and Border Protection or any other law enforcement agency in a motor vehicle and flees from federal, state, or local law enforcement in excess of the legal speed limit can be charged with and convicted of high-speed flight from an immigration checkpoint. Furthermore, many decades of prosecution and case law make it perfectly clear that fleeing law enforcement is a crime involving moral turpitude for which a conviction will render a non-citizen, whether documented or undocumented, immediately deportable and inadmissible to the country. In other words, what they're dragging us through again is already against the law. So if all of it is already a crime, why do we need another version of it? Except for plainly opportunistic political purposes. And I know those are the only bills they've been bringing forward. They've got no other agenda for the country, and they've handed over the legislative authority of the Congress of the United States to Elon Musk, the fourth branch of government. But in any event, they want us to pass again something that's already against the law. Well, we don't need it. And in fact, this characteristically poorly drafted pile-on bill is so poorly drafted this time that it could subject not just undocumented people, not just permanent residents, but American citizens to prison sentences for conduct that the vast majority of Americans would not even recognize as a crime at all and would not see as a crime. Now, unlike existing federal law or similar state statutes, the bill does not define what it means to flee. In their haste to get this to the floor, they just rushed over that element of the crime, which is of extraordinary interest to every other jurisdiction and even Congress before when dealing with it. But leave that aside, it does not even require evidence of criminal intent, a guilty mind, what lawyers call mens rea, the intention to do the evil thing. In other words, this bill does not require a person to know that they're fleeing Border Patrol in order to be charged with a crime. Now think about it. It applies to citizens, not just non-citizens, and you can be prosecuted and jailed for fleeing from a Border Patrol that you didn't know was Border Patrol. This is a radical departure from the prevailing rule in American jurisdictions. For example, in Maryland, I looked up my state, the offense of fleeing or eluding law enforcement requires that a uniformed officer gives a person a visual or audible signal to stop and prominently displays their official badge or other insignia. If an officer is not in uniform, Maryland requires that an officer give a visual or audible signal to stop while in an officially marked police vehicle to establish the necessary mens rea before we put somebody in prison. Under either circumstance, a visual or audible signal can be by hand, voice, emergency light, or siren. It's not only blue states like mine that require evidence that the accused knew what they were doing was wrong before convicting them of purposefully fleeing law enforcement. That's the rule almost everywhere. I'm sure the crime subcommittee chairman, Mr. Biggs, and the sponsor of this bill, Mr. Siscomani, are aware that in Arizona, the offense of unlawful flight from pursuing law enforcement requires proof that the officer's vehicle had markings indicative of an official police vehicle. Evidence that the driver knew that the vehicle was an official law enforcement vehicle, or the defendant must admit knowing that the vehicle was an official police vehicle. In other words, their own state takes the exact painstaking precautions that they just run roughshod over in order to get this bill, which has not had a hearing, to the floor of the United States House of Representatives. And should a defendant choose to exercise their right to trial by jury, the trial judge in Arizona would instruct the jury that they may consider whether the officer operated their emergency lights or siren to determine whether the defendant is guilty of unlawful flight from an actually pursuing vehicle. As was stated in the collaborative reports, Without Intent and Without Intent Revisited, published by the Heritage Foundation, which is adamant about mens rea, and the National Association of Criminal Defense Lawyers, quote, ensuring that an adequate mens rea provision is included in statutes and regulations that create criminal offenses is critical. The Heritage Foundation says it is critical to specify that there must be a culpable or guilty state of mind before we put people behind bars. It appears that nearly every state recognizes this fact when drafting their statutes carefully to address the fears and consequences associated with people fleeing law enforcement. We don't want people going to jail because they were simply moving away from a person they thought was a criminal who turns out to be, for example, an undercover police officer. As a matter of fact, of the states represented by the 32 co-sponsors of this legislation, all but 2 of them specifically require, at minimum, an audible or visual signal to stop the vehicle to prove that there was intentional flight from a pursuing officer. And looking at statutes that address similar conduct in all 50 states, there are only 6 that do not explicitly require an order, direction, request, or signal to stop the vehicle. Despite this widely accepted approach to legislative construction, H.R. 35 would allow Donald Trump's Department of Justice to not only convict non-citizens but citizens of a violation of this so-called offense, and to deport non-citizens without allowing them their day in court and without requiring any evidence of any knowledge that they were actually fleeing a government agent. Without any limiting characteristics under this bill, a citizen could be sent to prison because they did not immediately pull over when hailed by someone, a local undercover officer, for example, assisting Border Patrol. Similarly, in the immigration context, admitting to acts that constitute this nebulous, vague conduct would render a green card holder deportable. Now, the bill applies its criminal and immigration penalties even if the law enforcement officer is in plain clothes and driving an unmarked undercover vehicle. There are a lot of good reasons why a law-abiding citizen or permanent resident might be wary of pulling over for an unmarked vehicle. Just last week, reports emerged of an alarming trend across the country of rapists, criminals, and vigilantes pretending to be immigration enforcement personnel and then targeting people that they thought might be undocumented in order to rape them or assault them or harass them or what have you. I saw on TV a case last night of a sexual assailant who accosted a woman and forcibly assaulted her while pretending to be an ICE agent. I saw that last night. Another man, Sean Michael Johnson, was arrested for impersonating a law enforcement officer along with felony kidnapping, larceny, assault, and battery after he impersonated an ICE agent and stopped a group of men in their car because he told them they were not lawfully present in the country. In this environment, Mr. Speaker, it would be neither unreasonable nor surprising for law-abiding citizens to be wary of pulling over for an unmarked car that claims to be working with Border Patrol. Further, given that the Trump administration is deputizing anyone they can to get to aid immigration enforcement efforts, the number of officers, both in police clothing and in unmarked clothing, to whom this law would apply is staggering. In backing this bill, our colleagues want to impose extraordinary criminal and immigration consequences for not immediately pulling over when an unmarked car driven by a total stranger hails you at a time when criminals, including a pardoned January 6th felon, by the way, are going around impersonating immigration enforcement officers. That is a real trend happening now. And I would love to be convinced it's not, if the gentleman has reason to think that all of these reports and arrests of people impersonating officers are wrong. But this is a trend in the country. And all of this simply to give more power to target immigrants, which already exists, just for the purposes of the legislative show. This is outrageous, and I urge my colleagues to oppose the legislation. I'll reserve at this point, Mr. Speaker.
The gentleman from Maryland reserves. The gentleman